The other route to getting a green card is called the consular process. As refugees, and after a certain period of time, they can adjust their status and get their green cards. And generally speaking, those individuals don't have to pay a filing fee. Hi, this is attorney Giovanni Diaz of Díaz Gaeta Law. I'm one of the founding partners and immigration attorneys here at the law firm, and this is another episode of our podcast. I'm flying solo today because what I'm talking about is a subject that I'm very well acquainted with, and a subject that seems to draw a lot of interest. And understandably, it's very important. There's numerous ways to get a green card in this country. But what we're going to do today is going to focus on the two most common routes to get a green card. The first route is what's called adjustment of status. That's for somebody who's physically in the United States and affirmatively applies for the application. They submit what's called a 485 application to USCIS, to immigration. The other route to getting a green card is called the consular process. It's for one of two groups of people. It's for people that are living outside the United States that are immigrating into the United States to be legal permanent residents, or it's for people who are here and are undocumented, and who, initiate a very long, arduous process where they ask for forgiveness and then they go to an appointment outside the country and present themselves to a consular or an embassy appointment and ask for an approval of a visa to immigrate to the United States. So those are essentially the two routes we're going to talk about: adjustment of status versus consular process. So first, we'll start with adjustment of status. Now, generally speaking, when we do a consultation with an individual, we always look to see if we can adjust status, because obviously the most viable route for my clients that are physically here in the United States is for adjustment of status. Now, there's adjustment of status for those that are being petitioned by family members. There's adjustment of status for people that get granted asylum, right? There's refugees that enter the United States as refugees, and after a certain period of time, they can adjust their status and get their green cards. So there's lots of different routes, I guess, to adjustment of status. But adjustment of status is basically the process of applying for the green card while you're here in the United States, where you're not asked to leave the United States and go to an appointment at a U.S. embassy or a consulate. Depending on how you adjust status or what your route is, I think really depends on, really kind of informs what the eligibility requirements are, because there are a lot of waivers and special considerations for individuals who enter the United States as refugees or are win their asylum cases. So there's a little bit of flexibility and latitude in their adjustment of status eligibility. And generally speaking, those individuals don't have to pay a filing fee when they adjust status, and they don't have to show that they won't be that it won't be a public charge in the future. So a lot of requirements that, for instance, exist in the adjustment of status process through family members, a lot of those requirements aren't required when somebody adjusts status through a special humanitarian route, be it asylum, be it a refugee who adjusts status, or someone who adjusts under humanitarian visas like the T visa for victims of severe human trafficking, or the U visa, victims of crimes who participate and cooperate with investigations. So yeah, that's adjustment of status. When folks consult with me, we first have to determine what the route to adjustment of status is. Is there an immediate family member that's petitioning for them? Do they have special immigrant juvenile status and their petition is current? Or are they a beneficiary of one of these humanitarian visas, and is everything current? So once we determine the route that they're going to take to get adjustment of status, we have to determine if they're eligible, if they have any issues of inadmissibility. So what are issues of inadmissibility? These are things that impede the adjustment of status. Certain issues of inadmissibility are waived automatically depending on the route that you use to get the adjustment of status, but some of them require sometimes a waiver. And in most instances, if there is an issue of inadmissibility that requires a waiver, the waiver can be filed in conjunction with the adjustment of status or green card application. And a waiver is just a forgiveness. You're asking for forgiveness. The form it's a form, it's called a 601, and we just include that in this giant packet that we submit to immigration when we ask for the adjustment of status. So, part of the representation is to determine if they're eligible for the waiver and what is the probability of success of winning that waiver. Because anytime somebody affirmatively applies to USCIS to immigration, they're essentially availing themselves. They're turning themselves in. They're letting the federal government know that they're here, that they want to immigrate or get, to the United States permanently, that they want to be legal permanent residents. So there's always risk involved, and there is this concept or this idea that because of current policy, that those risks are elevated. And in a sense, they are, okay? But for the most part, almost all of our adjustment of statuses have been approved. So if you qualified for adjustment of status, let's say before the policy changes during this administration, you more than likely still are eligible and are an excellent candidate for adjustment of status. If you use, for instance, the Atlanta field office as an example, because our office is based in the Atlanta metro area and most of our cases come out of that office, the adjustment of status cases there really generally get done within a year. Within a few months, sometimes these green cards are approved, and sometimes they're approved before even the work permits get approved. So what I mean by work permit is if you file for adjustment of status, because sometimes it takes a while, depending on how you're asking for adjustment of status, you can request a work permit. So you can temporarily work here while immigration adjudicates, and that's just a fancy word for decide, right? Decides the application. So you can get that work permit and then you wait. Some adjustment of statuses require an interview at the field office. Some of them don't. I think the regs will tell you that there's no requirement that you have the interview, that it's up to the discretion of the officer that's adjudicating the application. But in our experience, if it's through special immigrant juvenile status, if it's through U visa, T visa, if it's through an immediate relative, let's say a U.S. citizen child that's petitioning you, those, if the application is prepared correctly with all the requirements, and we respond to any, let's say, requests for further evidence or anything like that, then those cases are usually adjudicated or decided without an interview. So that's a positive thing, and that's something that we can confirm. Now, the cases where we generally don't avoid an interview are cases that are marriage-based. So marriage-based cases generally do require an interview. Why? Because one of the requirements for a marriage-based petition is that you demonstrate that it's a bona fide marriage. Now, if you're a U.S. citizen and you've been married to this person for many, many, many years, and you have children, there's a possibility that that adjustment will be approved without an interview. But if it's a relatively new marriage, and maybe there's no children, or there's not a lot of proof of the bona fides in the original submission, then that adjustment of status may ultimately require that interview. But interview is part of the process. What we do for our clients generally, and I think it's best practice, is we have a really long meeting of preparation with the client and whoever the petitioner is, and then we prepare, and then we also accompany our clients to those adjustment of status applications. Now, obviously, we could talk for hours about adjustment of status, but for the sake of brevity, I think that basically that's a summary of what the adjustment of status process is. Now, let's talk a little bit about the consular process. What is the consular process? Like I stated earlier, the consular process is essentially, a process that requires an appointment at a U.S. embassy or a consulate. And I'll just give a very brief example. I'm a U.S. citizen. My wife is a Mexican national, and I want to petition for her. She lives in Mexico, so I petition for her. They approve the petition, and then we move on to the consular process. We fill out all these forms, we file these applications, and eventually, once they have once the State Department has everything they need, then they'll say that I'm documentarily qualified, that my client is, and then they'll set up an appointment at the U.S. consulate in Ciudad Juarez in Mexico. That client will go to that appointment, and if everything goes well, their visa to immigrate to the United States will be approved, and the moment they enter the United States, they are legal permanent residents of the United States. So that's the most common example of what the consular process is. But we also do consular process for a lot of our clients who are undocumented here in the United States, because within the immigration law there exists waivers or forgivenesses. Now, these are not easy to get, but because of 15 years of practice, we've become very good at getting those waivers approved for our clients. So, for instance, we have a client who's lived here for a long time. They're married to a U.S. citizen. They want to do the consular process. The reason they have to do the consular process and the reason they can't do adjustment of status is for one very important reason. And this is the reason that basically distinguishes most cases of consular process and adjustment of status. It's the way you entered the United States. So again, a lot of what I'm speaking about are generalities, and there are exceptions to all these. But generally speaking, if somebody enters with inspection, meaning with parole or with a visa, they are eligible to do the adjustment of status here in the United States. If somebody enters what we call without inspection, meaning they cross the border, the southwestern border or the northern border with Canada without any permission, and they've been here undocumented, they are what we call iwi, enter without inspection. And those generally are the people that are forced to do the consular process, which forces them to ask for forgiveness for living here undocumented, and then to comply with the requirement of entering legally, they have to leave and show up at a consulate or embassy outside the United States. So part of the consular process, marriage petitions, employment visas, K-1s, so the famous fiance visa, that's one where the consular process is involved. It's a process that even under the current administration and the current climate, it's still working. We get visas to immigrate to the United States granted just about every week in just about every embassy and consulate that does that work in Latin America and also all over the world. We have clients that immigrated from Northern Africa, from Sub-Saharan Africa, all over Asia and Europe. So we're pretty proficient in the consular process. We have a consular process department. And if you have any questions about whether or not you or a family member or someone you know can take advantage of the consular process or the adjustment of status, what's the appropriate route, what risks that they're incurring in trying this, please give our office a call. We don't charge the first consultation, and that's something that we have been doing since the inception of this company, that we will continue to do during this time of uncertainty and crisis in the immigration world. So first consult's free. You can call us at 678-503-2780, or you can send us messages on social media and we'll get back to you very, very quickly. Again, I'm Giovanni Diaz of Díaz Gaeta Law, and it was a pleasure talking to you about consular process and adjustment of status.